We are back in Senate Judiciary on January 14th. We have Gordon from the ACLU here to testify on Senate Bills 208, 209, and 178. And Gordon, the board is yours. You can also introduce yourself.
Thank you. Good morning, everyone. For the record, my name is Gordon Souter. I use he pronouns. I'm a policy advocate for the ACLU of Vermont. And I want to thank you all for inviting me here to testify today on S208, 209, and 178. Particularly on 208 and 209, we are grateful to this committee for taking up these issues early on into the legislative session. We know that there is a lot of community support and energy behind this. And so we're thankful for addressing these issues, especially at the time that they require it. Particularly requiring proper law enforcement identification, as well as ensuring that protections around sensitive locations are two priorities in our Firewall for Freedom campaign around immigration rights. And while we think that these measures are great first steps, we hope that this committee will continue with the conversation, keep the momentum going, and consider our other priority areas, such as improving detention conditions, as well as ensuring consistent legal representation for civil detainees, as well as creating a state cause of action around against federal officials who violate federal constitutional laws. All of which we're happy to share more detail in the near future. So by enacting these policies, we believe that Vermont has an opportunity to protect our communities, our civil liberties, and our democracies. So moving on to S208, requiring law enforcement identification, we are supportive of S208. We all deserve to feel safe in our communities, but as this committee is aware, community safety requires public trust in law enforcement, which that trust can be undermined when we have armed masked federal agents wearing plain clothes, driving around in unmarked vehicles, going around arresting members of our community without warrant, warning, or identification. They seem to act with impunity, with very little oversight or accountability. And without any form of accountability for government officials who violate the law, our communities will never feel safe enough for peace. So we support this bill's attempt at addressing many of the troubling trends that we're seeing around this issue and require that all law enforcement operating within the state of Vermont be properly identified and not conceal their identity. And we believe passing this law is important because we want this for our law enforcement as well. And while fortunately we're not seeing this as a huge issue amongst our law enforcement, we want that to continue. We want to continue following best practice and hold our law enforcement to a standard that builds trust amongst our communities and promotes public safety. And it's important to note that Vermont is not alone in this type of legislation. Dozens of other states have introduced bills like this. Most notably, California passed its law enforcement ID requirement bill, and other states such as Illinois, Massachusetts, New York, Pennsylvania, and Virginia have introduced similar legislation as well. Now, it's true that California's bill is being challenged, but from my understanding, the main point of contention there is that California's bill was targeting federal officials specifically and didn't apply to all law enforcement across the board. So with regards to 208, that does officially apply to all law enforcement operating in the state. It's much more defensible on that from that point of view. However, we understand that if this bill is trying to include federal officials within that bill, we understand that there's still a high likelihood of lawsuit, which isn't really indicative of anything other than that the legislative decided to oppose it. So the question isn't whether or not it's likely to face lawsuit. The question becomes, will it uphold in court? And we say, yes, it does stand a good chance of being upheld. I understand that you will be speaking to Professor Bowman Posen tomorrow, discussing constitutional matters around this. So I won't go too deeply into it now, but broadly speaking, we of course anticipate the federal government is likely to raise objections under the supremacy clause. But when analyzing the supremacy clause question, we ask two questions. First, does the state have the power to regulate officials? We know that states can't single out federal officials specifically, but states can pass generalized laws that federal officials must follow. For example, like speed events and such. And as I've mentioned, that this bill does not single out federal officials and applies to all law enforcement operating in Vermont equally. And Vermont has an interest in regulating some police matters. So with that in mind, now we ask, is the thing that we're trying to prohibit the federal government from doing necessary and proper to accomplish their federal goals? So is masking, is driving around in unmarked vehicles and concealing their identity really an essential part to ICE's function and what is tasked to do by Congress? And we say to that, no. There's a lot of arguments that agree with that would be no. And so generally, applicable state regulation is valid in that regard. So all that to say, we understand that there's a likelihood that we'll see a lawsuit over this bill, but we believe that it is very defensible and stands a good chance of surviving the clause challenge, and so are in support. With that in mind, we do have a few proposed changes, or additions, I should say, to this bill. Specifically under the identification requirement section, we would recommend that the name of the agency the officer be included in the identification requirement. We see many agents are identified with a police logo, which makes it harder for people to exercise their constitutional rights when they're unable to identify an agency. Not to mention how easy it is to get one of those badges. I could pull it up on Amazon right now and purchase one, which goes to people's fear of when they're interacting with an ICE agent, are they actually interacting with a federal official or are they acting with a potential imposter? So seeing that come up recently. And so requiring law enforcement to show which agency they're with would go towards building credibility amongst law enforcement as well as promoting safety. We also had some questions around the penalty section of whether or not this section is criminal or civil in nature, and would just recommend that the committee clarify its intent. And before moving to 209, I'll pause if there's any questions.
I think your point's well taken with the penalty section. I expect we'll hear more about this tomorrow, but I think that is the area in which we could run into issue if we are attempting to impose a criminal penalty as opposed to a civil penalty. And then the question is, what is that civil penalty? Is it essentially a traffic ticket? So that's one thing that I've noted to discuss tomorrow.
Perhaps this would be better answered for me. Actually, you know what? Never mind. I'll wait till tomorrow to ask that question. I won't answer it.
Any other questions on this bill? Does anybody need copies of the bills that they don't have?
I have lots of bills, but not that one.
I got it. You need them. Okay. There you go. All right, please, I'm good. 209.
Regarding 209, we are fully supportive of it. Going back to the issue of public safety, we also deserve to move freely throughout our communities and access public spaces without fear of harassment or abuse. But with the Trump administration's mass deportation campaign and an increased targeting of community spaces like schools, hospitals, and even places of worship, people are rightfully afraid to access these spaces, thereby preventing them from being able to utilize them and their essential services, which can jeopardize not only their livelihoods, but in some circumstances, perhaps even their very lives. So once again, we appreciate this committee's effort to promote community safety within this bill. Now, while supportive, we do have some concerns with the way this bill is currently drafted, and we just want to bring it to this committee's attention. Again, fully supportive of the intent behind the bill, but just want to recommend a few tweaks and suggestions that would make it more defensible. So first off, the law in this area is still developing. Historically speaking, there are two sources of law for protecting spaces, right? We have, first, we have courthouse and state houses, which is rooted in solid common law protections. And second, we have private spaces, which needs Fourth Amendment protections. We think this bill is right in focusing on extending protections of courthouses, as case law says that's where we're on the most safest constitutional grounds. But as written, this bill seems to be just a codification of courthouse privilege, which has not historically applied to other locations like schools and hospitals. So to tie courthouse protections to other places, you would want to make the reasons for prohibiting arrests at those locations as analogous to courthouse arrest prohibitions as possible to strengthen the case. Or, of course, you can tie them to other protections, such as the Fourth Amendment, where people have a reasonable expectation of privacy, or the 10th Amendment, focusing on the state's power to protect its sovereign interests. So, to bolster the state's case, we would recommend the purpose section to enunciate the state's interest in enacting this legislation and why it should extend common law protections around courthouses to other locations to protect state and local interests. And we, of course, bring this up because our primary concern would be folks relying on this bill, thinking that they're protected in these locations, yet still being arrested because it would be held in court. So we would want this bill to be as explicit in its intentions to give it the greatest chances of surviving a legal challenge.
Senator Bohos, you have a question?
Yeah, I'm wondering if the ACLU has any proposed language for that purpose section, or if you might be willing to work with me and legislative council to draft something.
Yeah, I don't think we have any language currently, but we'd be certainly happy to work with you on this. And then lastly, on S209, we also, going back, we also recommend including a severability clause in case if one part of the bill is struck down, the rest would remain. And then lastly, on 209, we just want to highlight the judicial warrant exception, not making any proposed changes. We appreciate its inclusion. We know that the judiciary has historically been a powerful check against a kind of overreach. And so we think it's important that this bill includes it, which makes it both legally defensible, but also puts agents and all law enforcement through that administrative hurdle, the intentional administrative hurdle of obtaining a warrant, which can stop potentially many bad arrests or arrests when they don't have enough of that, so they could get a judicial warrant.
I think in terms of the severability, similar to S208, I believe this would be covered under Title I BSA 215, which covers all acts. It says that if a provision of an act is valid or any application, and so on and so forth, since the severability clause applies almost universally. So you can double check that. I know it applies to S208 and confirm whether or not it applies to 209. Want to verify that. I saw Senator Norris here hand up. Senator.
Oh, it was mine. So just to clarify, the severability that you're seeking would be for individual items in this list. So if the schools were found to be constitutional and state county municipal,
Correct, then it wouldn't stretch down the rest of the location as well.
got it. Thank you.
But good to know about the severability cost of the sections.
Did you ask your hand up?
It was to make the point interest for me too.
And that's all I have on the 208, 209. And then with regarding S178, an act related to speedy trial procedures, fairly short and sweet, as we didn't see any red flags around it, and we're fully supportive of this bill. We understand it to be a way to address the court backlog that we know eats up a lot of court time and contributes to a lot of issues we're seeing with efficiency. And we're particularly in favor of this bill's attempts to shift the burden to the prosecution just by keeping the case going after a lengthy amount of time, which calls into question the person's right to speedy trial. And that if it's testimony I have prepared.
Thank you. Going back to 209, there was one question I had. This might be a question for an education attorney, but regarding the definition of school, I know that this is something that we grapple with in the education committee. And do you have any thoughts on how we define that? Because school can be very broadly interpreted.
I don't have any specific language regarding the definition of school, but we're generally supportive of broader definitions to try to make it to ensure that these protections reach the widest range of education as possible.
One last question. Can't remember if you covered this, but you briefly discussed adding churches, places of worship into the prohibition section on page 2. Did you have a position on that?
Yes, so it's very like a legal gray area that because because churches like obviously like the private sector, that we wouldn't be able to force them to like comply with this law, but what we would recommend just that a guidance section for private sectors would be included. And we've been working with the HRC on this, and they've expressed interest in working with us and potentially drafting up guidance for the private sector and how they can exercise those rights.
And I just want to clarify, your hope is that once that guidance is drafted, be included in this bill. Okay, so we should probably add the HRC to witness list.
Yeah. Maybe any other questions? Okay, great. Well, thank you. We have 45 more minutes left. I thought this was going to take a bit longer. Will, is that? Okay, well, I know you expressed an interest in testifying, sorry for the short notice, but since we have a lot of time left, would you like to testify right now?
No está dando la chance de dar un testimonio a un documento preparado. ¿Te interesa decir algo al comité? O si no te sientes preparado, voy a hacer del mismo tema de eso. Thanks very much for the offer, Chair. I would be happy to say a couple words accompanied by Agustin as a migrant justice member who would be prepared to testify at this time. I'd also be happy to hold off for another day. I'm not prepared to speak in too much detail about the specific amendment language. Although we aligned with ACLU on what the chief said, but if the committee's interested in hearing from migrant justice sort of more broadly around the patterns and impact of immigration enforcement activities of the state, we'd be happy to invest in that.
Yeah, I mean, yeah, we've got plenty of time, and if you want to speak broadly, you're welcome to do that. If you have more specifics you want to provide at a later date, you can also do that. So, yeah, please. Thank you, Jordan.
I'm happy to follow up with any of anyone has any
On the agenda that. Are we doing my justice? You can back to the courthouse still coming up. Yeah. Hopefully, yes. Thank you. Okay.
Thank you, Chair. Thank you, members of the committee. My name is Will Lambeck. I'm here speaking on behalf of Migrant Justice, the Farmer Human Rights Organization based in the state of Vermont. Migrant Justice has been around for about 15 years, building power in communities, particularly those who are living and working on the dairy farms in the state. Although over the years that community has broadened and is now throughout the state, living and working and many different economic sectors and industries. Yeah, with apologies to some of my house, you heard this yesterday as we were speaking, but yeah, the last year has been one of the most difficult for communities in the state of Vermont. While there's no hard data that's coming from the government itself, based on Migrant Justice's work and observations, we've seen more than a tenfold increase in immigration enforcement activity in the state. We have worked with and documented the detentions of over 100 Vermont residents by ICE and Border Patrol. This is much higher than anything that we've experienced before, given the first Trump administration. And it's really quite difficult to underscore the sense of crisis and psychic trauma at that level that number of detentions ranges. Each person detained is suffering a lifelong trauma. Each detention represents a family that's being separated and a community that's being terrorized. These detentions happen around the state. From both agencies. What's important to understand is that Border Patrol operating Vermont is not solely focused on what they term border apprehensions and blocking the Canadian border and costs. They're also heavily engaged in what they term interior enforcement. And as this committee knows, they have 100-mile buffer with the majority of the state they operate. So we've seen detentions through workplace raids. We've seen them through traffic stops. We've seen them through stakeouts of people's homes. We've seen them sort of arresting people one by one, or detaining one person on their way to work. And we've seen large-scale detentions of 8, 9, 10 at a time. While we oppose all immigration detentions and believe that these are all violations of people's rights, we think it's also important to underscore that contrary to the rhetoric from the federal government, the vast majority of the people being detained have no nexus with the criminal justice system. These aren't, what the government would term criminal aliens. I want to use that term in scare quotes. The vast majority of people have no criminal convictions, no criminal charges, no interactions with local and state law enforcement agencies prior to their detention by immigration agencies. We know that Hack Corrections is going to take testimony on the role with the Department of Corrections in this later on. Most people who are being detained in the state are then sent to either Northwest State Correctional Facility or Chittenden Regional Correctional Facility for men and women, and held there. Oftentimes to other detention facilities around the country. So it's also mentioned Michigan or Arizona, and Mexico or Texas, and the time that people spend in detention for those transfers is just traumatic and dislocated for the individual and for families to really just know where your loved one is and understand what's happening to them in the process. So we think it's very important that Vermont use every mechanism available within the legislature, of course, to do what we can to protect the communities who are so important to the economy, community, and culture of the state of Vermont. We think Duane and Duane are very good starts. We work with this committee and with Senator Bruce to have the original language around civil detention houses. That has been very effective. This was a common practice. If you would go to Costello, you go into Court of Middlebury, and you would see ICE agents sitting in the alleys of those courthouses. Once this bill, or once that bill became law in 2022, that practice stopped. And that's really important to understand. At the time, there were legal arguments on both sides. We felt very confident that the law had a strong legal basis. But there were some questions. Is DHS, is ICE going to play by the rules? Vermont tells them no arrests on courthouses. And the answer was yes, they have. We have not seen a single instance of an arrest of an individual at the Vermont courthouse, or excuse me, at immigration detention of an individual at the Vermont courthouse, or somebody on the way to or from the Vermont courthouse. They've complied with the law as the legislature passed it. So I think that's a really positive signal in terms of sort of what the impact of the legislation could be when it runs up against potential challenges with the supremacy clause. And we should all be very proud. You all should be proud that the work that the legislature did to take what was once a common practice that not only resulted in people's detention, but resulted in a threat to the integrity of the Vermont's judicial process. People not feeling comfortable going to court, and that practice is in stand out in the state of Vermont. So we hope that we can take that as a prologue for what's to come, and really go as far as using the levers that the Vermont legislature has to do everything possible to protect the community. So we want to echo what George at the ACLU said about hoping to amend the current laws and insert additional legislation that would provide more protections for the communities. And in particular, we're looking forward to this committee taking out what we believe will soon be a bill coming out of Legislative Council, starting in the House, if I'm not mistaken, to ensure universal representation for all people in the proceedings in the state of Vermont. That's not from the committee yet, but we think that is likely the most impactful thing that the legislature can do to ensure due process for the communities where really facing unprecedented levels of attack.
Thank you. Committee, any questions?
I do have one. Well, it seems like we're all putting band-aids on things here at the state level. Is migrant justice or ACLU actually doing anything with our federal delegation so they can address these problems rather than us constantly addressing the problems they are not addressing?
Yeah, it's an excellent question, Senator, and absolutely. I mean, this for Vermont is I don't know what the appropriate metaphor would be, but yeah, I mean, trying to hold back the flood for an issue that really at its core is a federal issue. We know the last time that there was significant immigration reform at the federal level was under President Reagan. We think that the Vermont federal delegation is doing what they can to try to advance a realistic solution at the federal level. But we're under no illusion that we don't think that this Congress and this administration is interested in real reform that would create lasting and stable protections for the millions of people throughout the U.S. and the thousands of people in Vermont who are living and working honorably and contribute to the community, and using them displaced from their countries and are due to actions from the United States. So we would love to see a solution at the federal level that would take this off Vermont's hands. But we also don't see it coming this year. That's an understatement. And so Vermont has a responsibility to act. Thank you.
Well, in regards to 208, can you speak to whether you or for the constituents of your organization see law enforcement wearing masks, whether federal agents or state or local police? Is that something that folks are seeing in Vermont? Are there instances of it?
Yes. Yeah, we have seen masked agents. It is a very common practice for agents not to identify themselves when asked, and to be wearing civilian clothing and driving in vehicles that are unmarked vehicles when conducting enforcement activities. It's long been ICE's practice to drive unmarked vehicles and wear civilian clothing. In the past, it would be more common for an ICE agent conducting a detention to have a lanyard with a badge. We don't see that as often as we used to. In a worrisome turn too, it used to be quite rare to see Border Patrol not in uniform. Well, I think accustomed to see, the white truck with the green stripe and the green Customs and Border uniform. We've seen a number of Border Patrol mass immunity detentions, pulling over a van of roofers on their way to work and arresting detaining a group of people. They are not wearing uniforms in some of those actions. So we're seeing a sort of move in the wrong direction in that sense.
Thank you. Any other questions? Uncle, did you?
For the record, Bob Schilling, Embassy Director, ACLU Vermont. I just wanted to address Senator Norris's question about our work with federal delegation. We're in regular contact with members of the federal delegation and have been talking with them about what they can do on the federal level to help, make sure that they are curbing some of the practices which we see, which are the most concerning, that there's adequate training, and that those rules and regulations are being followed, and also concerns around the level of funding that's going to these agencies with the lack of accountability. So to shortly answer the question, we're in touch with the federal delegation, but I also second Will's view on the likelihood of seeing federal action to address these coming out in the coming year. But thank you for your attention, Senator.
So thank you, Will, for testifying on the short notice.
Absolutely. Yeah. Thanks for the invitation, and hope we'll be able to come back to the committee in the draft session as well. Of course.
So committee, I think we have a intense morning, so I think we can save the discussion on this for another day and speak on break through it.
Don't oppose it.
Yeah, great. All right, thank you.
For the record, Bob's a yes.
I don't want to call the roll.